Okay.
All right, we are now live. Before we figure out if we're going to go on the record for Mr. Kojo, have you, Mr. Franklin, had a chance to talk with Ms. Hall? Is this something that is negotiated, or what are we doing today?
So yes, we've had a conversation. We actually had a couple conversations about it. And before knowing your personal history with Mr. Kojo, what we had determined was that with there being a new underlying unindicted indictment, that we thought it would have been best to track with that case once it's indicted. But given your history with, I'm not sure if you are interested in kind of it working backwards, where we would try to inherit the new case once it's indicted, and just hold on to the revocation until then.
Why don't we can discuss that. So we'll go on the record in a minute, but that I understand your point. Is the alleged victim in the new case a family member or a stranger?
From what I understand, and I've seen the actual reports, it looks to be like an Uber driver, and that's based on my conversation with his mom.
Okay.
So it would have started based on the young lady was at the home. She and Mr. Kojo, per the mom, were having an argument. The woman left, and then when they get outside, there's an Uber driver and perhaps something ongoing with the Uber driver. But that's all based on my conversation with the mom. I haven't read anything to let me know one way or the other.
Got it. Okay. Well, why don't we get on the record? This is position 1 on our calendar. It's 15 SC 137622. State versus Jonathan Kojo. Hello, Mr. Kojo. Are you able to hear me? Can you say that again?
I can hear you.
Okay, good. How are you doing?
Not good.
Oh.
He needs to speak up. I cannot hear him.
Yeah, Mr. Kojo, can you get a little closer to the microphone?
Yes.
If I may interject, when I spoke with Mr. Kojo previously, he spoke very low.
Okay.
And I couldn't hear a bunch when we were trying to have our discussion at the jail.
That's my recollection as well, which is why I was just suggesting to get close to the microphone. I'll limit the number of questions I ask him. Let me start then with Ms. Crawford. Ms. Crawford, how much time remains on Mr. Kojo's case?
Good afternoon, Judge. Mr. Kojo has 8 years, 26 days remaining on his case.
Okay, so quite some time. Ms. Hall, do you have a CP number for the unindicted charges?
Yes, Your Honor. It is 20 CP 190969.
All right. And I'm assuming, as usual, you don't have any particular insight as to when this might be indicted?
No, Your Honor, but I think it'll be a lot faster than some of our other cases. We have most of the evidence in this case, as in 911 calls, that kind of stuff, photos. So that means that we're on track for indictment. So it should probably get there a lot faster than a couple months.
Great.
But I'll still check with the complaint room. I'm sorry, the intake department and see.
Sure. 190. Okay. All right. I was just checking the docket. So your suggestion, Mr. Franklin, was to pause this and wait for the new case to get charged. And then I guess we can work with whichever judge that is assigned to, I'm confident that judge would gladly transfer it here if that is a more productive way to resolve everything. I don't know that I would transfer the revocation, but I am comfortable leaving the probation warrant in place, or the hold, while we wait for the new charges to be indicted, with a caveat that I'll probably have Ms. Nelson put this on a calendar a few months out. I don't want us to forget about Mr. Kojo. Not that you would, or Ms. Edelman would, who I think's been assigned to his unindicted case, your colleague. But I would want to just make sure that if for whatever reason the district attorney's office is not moving quickly to indict on these charges, that we then take up this issue of revocation. Mr. Kojo is working through a lot of issues, and I don't know that he's at his most stable when he's in custody, but clearly there are issues when he's not in custody as well. So it's a complicated one. I just want to make sure that whoever in the end is resolving the two pieces, the revocation and the new charges, is informed about some of the history, Mr. Kojo and his family. And like I said, I'm happy passing that information on to the judge who gets the other case, or it may just make sense to have that case come to us, assuming the parties all agree. I can't just ask a judge to send me a case because I want it. You'd need to agree with that as well. But for now, it sounds like we just stay where we are.
No, I haven't been indicted for that in a whole year. So they have a 3-month time period to indict me. I brought it April 1st, 20, but indicted by June 2020. They sent as on to the armed robbery to me. And I think that both her and her boyfriend wouldn't Uber driver contacted me like 2 days later. It's not pretty nonsense. I just like to go home to my mother and get back to the rest. I can get a new vehicle to the regular job. This is me remain both conscious and subconscious of my breathing to be able to my true sense of my rest of the world and get regular in society. So to go home, it's nonsense. I mean, that was like I said, 2026, I think it was. So like 3 or 4 years on that, and I went to the dentist office for the medical dental to try to get my video gameplay cognitive evolution started back then. They got to get my front tooth implant put in to be able to have money coming to that. That was practicing the preaching again, so many things. Basically being self-taught from getting regular work. So I just anyways, I'm pretty sure I know what I'm going to go over with this, whatever. So I was just have this going on preparation, be able to get regular sleep and be able to get a regular job and get things properly.
Mr. Kojo,
this is incoherent. I cannot understand.
I understand, and you can note in the record that you were not able to take down what Mr. Kojo had to say. Mr. Kojo, I've understood some of what you said, and I appreciate your observation that you've now been in jail for about a year on these unindicted charges, and you are I understand why you focus on the 3 months to indict. That deadline has been suspended during the pandemic. It's about to be reinstated, as I understand some of the legislation that passed late last night that will soon be signed into law. And so, of course, the district attorney's office is going to need to redouble their efforts to indict folks who've been in custody for a while. But the fact is you have no bond right now on those new charges, but you also are being held in the case you and I have worked on before, and I'm not going to set a bond on that until we can figure out a good, safe solution for your situation. So we will check back in. How far out do you want to say, Mr. Franklin? We want to set this at 30 days out?
I think 30 days is a good check-in time for us to see the status of the indictment, and then that'll give us a bit of time to get the new reports, at least among myself and Ms. Hall, to see if that would aid us in reaching a resolution.
Great. And it sounds like the district attorney's office has a fair amount of material about these newer charges. So they should be able to share some stuff with you if it hasn't already been shared with your colleague. And another piece of legislation that just passed, assuming it gets signed into law, allows many more offenses to be accused. Now, the state has to be willing to accuse something, but we have the possibility that as another way of streamlining this process is if there's a sufficient basis and folks want to move forward that way, there's always a way to proceed by accusation. But I just lay out those different opportunities. We will make sure that we check in with Mr. Kojo in about a month to see if the new charges have been indicted. If they have not, then we'll probably set down a date for a revocation hearing. And that will be another focusing mechanism to either get the new charges indicted or accused, or maybe there's a global resolution to the new charges and the revocation here. Ms. Hall, anything else in Mr. Kojo's case?
No, Your Honor.
Mr. Franklin?
Nothing further. I would tell the court that I expect to file an ex parte motion as it relates to Mr. Kojo.
Okay, I will be looking for that. Let Ms. Nelson know, and we will take care of it.
Yes, sir.
All right, thank you. Good to see you, Mr. Kojo.
Position number 2 is next, Judge.
Hello, Mr. Rogers. Can you hear me?
Yes, sir.
Great. We're going to get started with your case. This is position 2, State versus Ulysses Rogers, 14 SC 131510. Mr. Rogers, I have a document in front of me, a petition to revoke your probation that alleges that in April of last year, you committed a felony of terroristic threats. And then much more recently, February of this year, you committed an offense of crossing guard lines with some prohibited item. It may be drugs, because you were also charged with possession of cocaine. Regardless of the details, the allegation is that you violated probation twice in both instances for getting arrested or getting involved with criminal activity. Mr. Franklin, are you handling this? I see that we've got Mr. Hobbs on the call, and Mr. Hobbs is listed as the defense attorney. So I want to make sure I'm hearing from the right lawyer.
Judge, I represent Mr. Rogers now.
How are you, Mr. Hobbs?
I'm fine, Judge. How are you doing?
I'm well. You're looking very distinguished.
Yes, thank you. Sitting in my dining room, of course.
All right. It's the tie and the jacket and those snazzy glasses.
Mr. Franklin didn't tell me I didn't have to wear a tie when I talked to him yesterday. He kind of set me up on that one.
Yeah, apparently you can wear Madras plaid now, and it's all good. So there you go. So, Mr. Hobbs, the threshold question. Is this something that is contested, and we're going to need to set this down for an evidentiary hearing, or have you and Ms. Hall been talking, or where are we with Mr. Rogers?
Well, I've been talking with Miss Besa. We chatted a couple of times late yesterday afternoon, and then again about a half an hour before court. She was kind enough to forward me the warrant on the newer case as well as the police report on the older terroristic case. So Mr. Rogers and I have talked a little bit about it, but he's not seen some of the information that I currently have. I think before I would be able to answer that question for the court, I would like to have a little bit of time to kind of go over what I have with Mr. Rogers to see what he wants to do. I do understand that if, from speaking with the state, if it were to be a contested revocation, they would want to go forward with the terroristic threats case first, which obviously would have perhaps one, maybe two witnesses.
Okay. So Ms. Beza, I didn't mean to call you out of the case. It's your case. And is that because the underlying, this 14 SC case is crimes against women, or the terroristic threat? What your connection is the terroristic threats?
That is correct, Your Honor. The commitment to terrorist threats and it's all on body camera footage.
Okay, got it. And is that footage something that you've been able to share with Mr. Hobbs?
Not yet, Your Honor. If this goes to a hearing, we'll be ordering it either way. And then once we get it, the evidence.com will be forwarded to him. But I did share the police report, which states the exact minute and seconds the defendant allegedly said the threats and what exactly he did.
Okay. When you say minutes and seconds, not so that someone could look at their watch, but when the body cam footage is delivered, instead of having to watch 3 hours of it, Mr. Hobbs could jump straight to a segment.
That is correct. For example, like 8 minutes and 34 seconds into the video, he said this.
Got it. Okay. Mr. Hobbs, so tell me, I'm comfortable resetting this. I just want to reset it as few times as possible. So
Sure.
I don't know if you want to wait until the state gets the body cam footage, or you think that the paperwork describing what's on the body cam footage is adequate for you to engage with Mr. Rogers about the best way forward.
Well, I think the paperwork is sufficient for myself and Mr. Rogers to have a conversation about whether or not he wants to have a contested hearing.
Okay.
That makes sense. If we
Yes, it does.
go forward with the contested hearing, obviously we would want the audio tape, but there's enough information that I can kind of relay to him what they suspect, the state suspects the evidence would show, and then allow him to make a decision on how he wants to go forward.
Got it. And neither of these new alleged offenses is indicted or accused. They're both CPs.
That is correct, Your Honor.
Okay. All right. Mr. Rogers, we've been doing some talking. You've been doing some listening. Do you have any questions about anything that I've said?
Yes, sir. Okay. Last week, well, 3 weeks ago, when I was before you, which is my girl, she was on the camera too, who that said the terrorist threat was on, and they had written statement and that I no longer threatened her. The person who the threatened on, she was here on video, but she's not here today. But she has written statement that them been to Mr. Devin Franklin, and he transferred it to the DA. You know what I'm saying? I'm out on bond for that right now, and due to this new charge, I have a bond for this right now, and only thing is, my mom have cancer, and she right here on camera right now. You feel what I'm saying? If I do any time, man, I hope that I make it back to my mama. You feel what I'm saying? If I can bond out and go to daily report and or house arrest, anything, so I can handle these from the streets, man, can you please? Because you said that you was going to reinstate me last week. I was getting reinstated. You said you was going to revoke 30 days. You were going to revoke 1 day and reinstate me, but you didn't see that I had got caught up with this charge. You know what I'm saying? I have a co-defendant who on bond out in the streets right now, who's on this case with me right now. And I am in here, and I can see, can I just make my bond and get reinstated or anything? That way I can fight my case from the street and help my mom do as much as they can, because my mom needs me. Like, and she can speak up, she'll tell you, my mom needs me, man. My mom ain't never got me, man. Like, that's all, man.
Okay. Mr. Hobbs, anything you want to add?
Now, just to clarify, I believe that there was an attempt to work this out the last time he was on the calendar, and there was something conveyed to him about it being 30 days revoked, which would have released him. However, the court, my understanding from speaking to both Mr. Franklin and Ms. Besa, is that the court was unaware of the newer case, which basically put this back to where we are today.
I think that's right. I think what occurred was that I had an out-of-date petition that didn't have everything on it. And so we were working through one offense and not both offenses. And in light of being told, wait, there's this other one, and then it may even have been mid-hearing that Ms. Nelson was able to email, or it may have been Ms. Crawford, but someone sent the more current petition that was signed in February of this year. And that, to me, changed the equation a little bit, and that I thought we needed to sort out both these things. And I think it changed it for the state as well. Let me make sure, though, Mr. Hobbs, that if you're working with Ms. Beza, you're working with someone who could resolve everything. I know you wouldn't necessarily handle cocaine charges, but if Mr. Hobbs and you, Ms. Beza, reach a negotiated resolution, that would cover the entire petition?
Yes, that is correct, Your Honor.
Okay. All right. And you have provided Mr. Hobbs with everything that you've got, or you are in the process of providing him with everything you've got?
We provided with everything we have so far.
Okay.
Which is the warrants for the drug case and the police report for the terroristic threats case.
And it's that latter police report that has contents of statement and time of statement. And so what would round out the informal discovery for the terroristic threats case would be the body cam video. You're in the process of getting that sent to one of those evidence.com links, and then Mr. Hobbs would have that as well.
That is correct.
Okay. Well, Mr. Hobbs, Mr. Rogers gave this same plea last time. I had just forgotten why it was that we continued it, but now I understand. Let's try to keep this on as short a fuse as possible. If you would let Ms. Nelson know as soon as you're in a position to either argue a non-negotiated admission or a contested matter, certainly the state will need to get whatever witnesses the state needs to get into court. And we'll jump on it then.
And I will say this, I can let Ms. Nelson know as early as next week what Mr. Rogers' intentions are in regard to that question. And just to let the court know, Ms. Beza and I have been speaking about trying at least to get the surveillance tape from the drug case, because that case is based completely upon the officer viewing the surveillance tape and then making conclusions from his observations and charging Mr. Rogers. So in order to deal with the cocaine case, I don't mind doing that, but I would need some type of opportunity to look at that, because the entire evidence comes from the surveillance tape that the officer watched, not from his observations.
His direct observations. I got it. Okay. Hopefully that's something that's accessible. I think what concerns me more would be the combination of the charges that Mr. Rogers had in the 14 SC case linked to the alleged terroristic threats. I appreciate it was a year ago, but that is more of a family of why Mr. Rogers was on probation to begin with. And that's not to say we shouldn't worry about the cocaine matter, but it's more that following after this that suggests, well, maybe Mr. Rogers hasn't sorted out how best to stay out of trouble while he's on probation. I didn't realize that the drug case was based solely on an interpretation of a videotape, which isn't to say it's not compelling, but I hear you that it's not going to be based on an officer saying, I did a hand-to-hand transaction, or I was right there when one occurred, or it had nothing to do with hand-to-hand. It just, we pulled the car over, it didn't have a tail light, and in his pocket was 80 hits of crack.
Correct.
Your Honor, just for the record, there is a second charge on the drug case of crossing guard lines with prohibited items, which is a felony as well.
I see that. That just often means that the police didn't find something when they patted someone down. And then it didn't get discarded in the patrol car. All right. So let's do that, Mr. Hobbs. You let Ms. Nelson know, and then we'll get this scheduled as quickly as we can. I appreciate Mr. Rogers' desire to be out there for his mother. And I recall when we were on last time, the young lady doing her best to try to talk during the hearing about her thoughts about what did or didn't happen in the terroristic threats case.
Oh, excuse me, Raj.
Yes?
Okay, is it possible that, since I have bond since first appearance on this so-called, on this last charge, on this, where I got locked up for on February 9th, is it possible that I can make bond for that charge and fight those charges from the street, sir?
So that's something for Mr. Hobbs to bring up. If he learns that it's going to take a while to get what he needs to defend you in the revocation hearing, then that may be the right time for him to say, Judge, through no fault of mine, we can't get X or Y or Z that we're entitled to defend against this revocation. And so why can't Mr. Rogers, in the meantime, get a bond? And I'm happy to entertain that. That's not what we're doing today.
Yeah, I have a bond right now.
And I'll speak too. I'll speak to Mr. Rogers about that. We obviously, if we do a probation revocation on the terroristic threats, depending on how that contested revocation were to go, I'm sure I would have a motion on the other charge at the conclusion of that hearing.
Right. And Mr. Rogers, I got you. You got a bond on the other things. You don't have a bond on this petition. What's holding you in is the fact that you have allegedly violated your probation not once but twice by getting arrested for felony offenses. So I hear you that you have a bond. Mr. Hobbs can argue for you, it's really not giving you a bond, but it would be lifting the hold that the probation warrant represents. So that's what's holding you in. I hear you that you got bond on both those cases. You had to have gotten bond on the first one in order to pick up the second charges. So I'm following all that. I'm going to give Mr. Hobbs a chance to get a little more information from the state, and then he will let Ms. Nelson know whether we need to get everyone back together to talk about lifting the hold, or if we're going to actually talk about resolving your probation situation. Thank you.
Thank you, Judge. May I be excused?
Yes, sir.
Thanks, Judge. Good seeing you.
So yeah, can y'all tell me what's going on right now? I don't know what's going on right now.
So Mr. Hobbs is going to be in touch with you, and he'll let you know what's going on, okay?
Like, can you put me to a room right now with him so he can tell me what's going on? Please, sir. I just want to know what's going on right now, because I just want to know so I know.
Is there a
so
way?
Mr. Hobbs, if I put you and courtroom 3 into a breakout room, can you keep it to 5 minutes or less? You can talk to him for 100 days after it, but we've got other folks behind this.
Yes, sir. I can keep it to 5 minutes or less.
Great.
Excuse me, Judge. I'm sorry. Excuse me, Judge. He can call on the phone if I give him the number, please.
Great.
That would be great.
Man, look at my mom, man. That's crazy, man. Oh.
So, ma'am, do you need the attorney's phone number?
No, I can give it to him.
Okay, great.
404-612. I'm sorry, 613. I'm sorry. 4880. Mr. Hobbs, you can call that number.
Yes, ma'am. I'll call right now.
Thank you.
Thank you.
Thank you, ma'am. That's very helpful.
Thank you, Judge.
So position 3 has been resolved. Did we enter a PTI order, Ms. Hall?
Yes, Your Honor.
Great.
And the defendant is in the courtroom.
Oh, Ms. Jacobs?
Yes.
Hey, how are you? And your lawyer is on the call. So Ms. Snyder, are you there?
Yes, sir.
Great. Happy Thursday to you. Ms. Jacobs is here. I think I remember this order. I think that it requested a year to do 38 hours worth of stuff, and I shrank that to 6 months. But I did sign the order, and Ms. Jacobs has 6 months to take care of those pretty minimal obligations. Am I remembering the same case?
Yes, sir. That is.
Yes, Your Honor.
Okay. All right. Do you, Ms. Snyder, need me to share anything with Ms. Jacobs?
No, we've been texting. I just wanted to make sure she had been released because you signed the order and for a few days and then the bench warrant set aside didn't come through, but
Yep. She's here.
Happened.
When did you get out? Last night? Holy smokes, that took too long. I'm sorry it took so long, but you're out now. All right, let's keep you out, okay? You'll take care of what you need to take care of. You know what it is? Great. You just be in touch with Ms. Snyder if you have any questions about it, okay?
It's very hard to get in touch with Ms. Snyder. Like I talked even before the bench warrant was placed on me. Like I called her daily. I've had to reach out to your clerk, reach out to even the public defender for like the not felony, but what's the misdemeanor. I spoke to her. I spoke to a lot of people. And I only spoke to her once since this case has been open, since she's been placed on.
Okay, so you'd like to have more direct contact with Ms. Snyder. Okay, she has been moving offices. Her firm, the group of lawyers with which she works, has been relocated a couple times, and so that's made it harder to connect with people. Have you had the same phone number all the time? Okay, great. So Ms. Snyder, do you have a good phone number for Ms. Jacobs?
I do, and because of the issues with our phones in the office, I've gotten a Google Voice cell phone number that I've been texting her on, so it shouldn't be a problem going forward.
Okay, have you been getting texts today from Ms. Snyder? Good, so use that number. This is a happy change, and the texts are a sign that Ms. Snyder's always been there, but because their office kept moving and voicemail wasn't being forwarded, you're not the first person to say, I'm having trouble contacting a conflict defender, not just Ms. Snyder, but her colleagues as well. And that's been frustrating for everyone, me too, because sometimes the defendant is ready to do whatever needs to be done, but we can't connect. So don't lose that phone number you've been texting on. That's a good way to reach Ms. Snyder. It doesn't matter what's going on with her office because it's on her cell phone, okay? All right, be safe. You bet. All right, I think we are now ready for Mr. Robinson. Is that Mr. Robinson?
Yes, Judge. Position number 4, please.
Great. And I think we're having a bond hearing. Is that right, Mr. Franklin?
That's correct.
So I have a bond motion that your client wrote. I don't think you needed to have submitted one as well, but I think that's sort of what brings us together. Ms. Beza, are you prepared to go forward with the bond motion?
Yes, Your Honor.
Great, well, we'll do that. Mr. Robinson, can you hear us?
Yes, Your Honor.
Great, how you doing today?
I'm aware.
Good. So Mr. Franklin, relying on your bond motion, has asked that we get together to talk about bond in your case. I had tried to get your case to trial a few weeks ago, but as you know, your lawyer left private practice and has returned actually to the other side and is working for this district attorney's office. So we needed to figure out who'd be handling your case going forward. We had that conversation. Mr. Franklin has jumped right in and has said we need to talk about bond. So I'll hear from him and anyone else he may want me to hear from in connection with bond. Then I'll hear from Ms. Beza and whatever information she's got, and I'll let you know what we're going to do, okay? All right, when you're ready, Mr. Franklin.
Thank you, Your Honor. So as the court is already familiar somewhat with the case, Mr. Robinson has been in custody nearly 2 years at this point. We are making a request for a bond that is essentially a signature bond. I know we've had that conversation about that not really being what we have traditionally understood it to be at this point, but we are asking for a extremely reasonable bond that would factor in that he would be on an ankle monitor, and we are consenting to a curfew that would allow for him to continue working. At the time of his arrest on this incarceration, he was arrested while he was at work. At that point in time, he was working with Bring It Movers, a moving company. And when he gets out, if he is to get out, he has similar work available as a mover working for a Universal Moving Group. He would be residing with his mother, Ms. Shahida. She lives in off of Mount Zion Road. I have the exact address I'll give later on, or right later on if need be. He was born in Seattle, but essentially all that he knows is Atlanta. He went to elementary school here. He attended middle school here. He attended high school here. He did not graduate high school. He, at one point in time, was attending Atlanta Tech, trying to work on his GED. Wasn't able to finish, but he had been, as I stated earlier, working odd-end jobs, most recently the Bring It Movers job. He has a 9-year-old son who lives here, who lives with the mother of the child. So his mom, his life, his child are all here. So we believe he has significant ties to the community. As it pertains to the likelihood that he would be a threat to anyone once he were released, what we would offer the court is that the original charge on this case, the very first time he was arrested, it was for involuntary manslaughter and related gun charges. The charges were later indicted as felony murder charges, not malice murder charges. a very brief, I guess, relatively neutral assessment of the facts is that the victim in the case, Ms. Courtney Roscoe, was his girlfriend. In fact, I believe they were engaged at the point in time that she died. There was a weapon. I forget if it was a 9mm or a 380, whatever it was. There was a bullet in it that did not fit. So if it was a 9, it was a 380 inside of it. If it was a 380, it was a 9mm inside. He had tried to unlodge it with a screwdriver at some point in time. Was unsuccessful. So for a while, the gun had just been existing with the screwdriver stuck in it. They kept it around the house, and one day when handling it, it actually fired that day. And that is what caused the death of Miss Roscoe. Mr. Robinson hasn't missed a court date. The reason we're here, he came to a court date. I believe it was May, possibly, of 2019. And he left the court date prior to when he should have left. And so a warrant was put out at that point in time because he left court. And then I believe he was arrested about 3 months later, thereabout. I believe it was July of 2019. And he's not been in custody since. He's been in custody since that point in time. But we believe that this circumstance to be an extremely tragic, unfortunate accident. And therefore, we don't believe that he would be a threat to anyone going out before because this was an accident. And we believe that a bond that assures that he is monitored by his ankle, but allows for him to also work would be in the best interest of all parties involved.
So, in looking at the docket, I think it aligns with much of what you're saying. It sounds like the incident was back in 2017, and there was not an indictment. In like July 2017, Mr. Robinson had his first appearance post-arrest. But then the indictment is not for over a year, almost a year and a half. The indictment is the last day of November 2018. But there's an FTA issued in March of 2019. And you're saying your understanding of it is that Ms. Robinson actually showed up for court, but maybe before, I assume it was Judge Reeder, she signed the judicial hold, before Judge Reeder had dealt with his matter in her mind completely, he left?
Yeah, so I can flat-footed 100% say he showed the court that day because I was his attorney at that point in time.
Okay.
If I recall, I believe the ADA at the time was Adrian Love. I'm 99% sure on that. And I think the issue was that he had been out on bond on this involuntary manslaughter for a period of time, whatever that original date was up until this court date. But when he got to court, we learned that it was a murder case now. So it hadn't been, this was the first day that he learned that fact. And while they were trying to sort out the issue of whether he would be rearrested that day on murder charges, although he had already bonded out on the involuntary manslaughter charges, he left court.
Okay. In August of 2017, a magistrate reduced Mr. Robinson's bond down to $55,000, saying that it was reduced because the state had failed to indict and that Mr. Robinson has no felony criminal history. So I guess he was able to make that bond because that's the last entry about bond until we've got the indictment, which is for different charges. And so all of a sudden that bond's no good, I guess.
Yes, sir.
Okay.
The additional thing that I will add, I forgot to add this in my initial argument. Ms. Besa sent me an email to essentially memorialize information that she had come into. Someone from the GBI, a Miss Sarah Van Home, spoke to someone, spoke to Ms. Besa, and in some confirmed that it's possible that the gun went off accidentally, and that there was evidence that the chamber may have been fidgeted with to support the fact that this bullet that didn't fit in the gun was in fact in the gun.
Okay. Got it. Ms. Crawford, can you confirm that Mr. Robinson has no felony criminal history other than this situation?
That's correct, Judge. He doesn't have any history.
All right. Thank you. And how is it, Mr. Franklin, and it may be your client needs to answer this, that having been in jail for 2 years, he knows he's got a job at Universal Moving lined up for him? Is it a family work there, or how can he know this?
I didn't ask how he knew. I asked the question, did he have work available to him? And he informed me that he did, and he gave me the name of the company, but I'm sure he's able to talk about that.
Mr. Robinson?
Yes. It's a friend of the family. They own a moving company, and they said that as long as I get out, they have work guaranteed for me.
Okay. All right, Ms. Beza, tell me the state's perspective on this case. It is not your run-of-the-mill death by firearm.
That is correct, Your Honor. It's the state's position that no bond should be granted. You're correct. It's not the run-of-the-mill firearm case, which is my felony murder has been charged. I don't want to get into all of the allegations of the case, but since Mr. Franklin mentioned some of them, saying that, the defendant was holding the gun and then it accidentally discharged, I would like to put on the record that the allegations are that the defendant admitted that he shot Miss Roscoe while he was playing around with the gun. He was playing around with the gun while pointing it at her and chasing her around the apartment where they lived together. Not sure if that's some kind of game, but that is what he admitted to. He was pointing it at her. He was committing an aggravated assault, and in the process, she was unfortunately killed. Your Honor briefly went into the procedural history of bond. I do want to reiterate that he was in a no bond status from June 11th of 2019, which is when the no bond status was put into effect. And Mr. Franklin filed a motion for bond July of 2019. This is after the case was indicted. There's been no change in circumstances since that date. Judge Reeder denied bond, saying that he's a significant risk of fleeing from the jurisdiction or failing to appear, and he poses a significant threat or danger to the community or to any property in the community. Nothing has changed since then. Those reasons still stand today. That's why I want to get into the Iola factors at this time. It's the state's position that the defendant is a risk of intimidating witnesses in this case. There are 3 people that have witnessed the possessiveness or prior abuse of the defendant towards the victim in this case. Ms. Tammy Way, who is the victim's mother, saw the defendant become possessive over the victim in this case. She observed him be verbally abusive towards Ms. Roscoe as well, to the point where she even talked to her daughter about leaving the defendant. In addition, Ms. Nakia Bell, N-E-K-Y-L-Y-A, the victim's best friend, saw the defendant act very possessive over the victim and paranoid over what the victim was up to. She would be on the phone with Ms. Roscoe and could hear the defendant telling her to get off the phone, and that just shows the power and control he had over her. In addition, Mr. Rashawn Snipes, which was another best friend of Ms. Roscoe, also saw this control and how the defendant tried to isolate Ms. Roscoe by popping up at the park when they were at the park together, showing up out of nowhere when they were hanging out together. These are all people that the defendant has the ability to intimidate if released from custody. The main argument I want to say for the record is that the defendant has a history of failure to appear for this exact case. You mentioned it already. I have the order right here, March 9th of 2019. Judge Reeder instated a judicial order for failure to appear on the above referenced case. He is unavailable for prosecution, is what the order said. Mr. Franklin said himself, he was in court and the defendant left when he learned this was a murder case. This is still a murder case. So what is to say the defendant's not going to leave and not show up to court when he knows his charges are now murder? He's shown the court in the past that he will leave because he's charged with murder. Nothing has changed. He is a high risk for failure to appear. And if the court grants this defendant bond, as he's shown in the past, he's going to leave and not show up. Therefore, Your Honor, the defendant not only poses a significant risk of intimidating witnesses, but he also poses a significant risk, as he's shown in the past, of not showing up to court based on his charges. So it's the state's position that bond should be denied. One more thing, Your Honor. I do have the victim's mother, Ms. Roscoe's mother, Ms. Tammy Way, in court today. She would like to make a victim impact statement to the court. We aren't sure whether you want her to make it from the gallery, come up to the stand, it's whatever Your Honor would like, but she'd like to briefly address the court.
Of course, and I'd be happy to hear from her. Ms. Way, you should come on up. There's a table that's empty here that has a microphone. I need to make sure you are able to be heard by the court reporter. So if you would come on up to that microphone, and you're welcome to sit or stand, and I'll just make sure that Ms. Rivers can hear you, and then I would very much like to hear what you have to say. Are you comfortable?
Yes.
Okay. So why don't you say good afternoon?
Good afternoon.
Ms. Rivers, were you able to hear that?
Yes, I was.
Great. Can you spell your last name and then share with me, please, what you want to?
My last name is Way, W-A-Y.
You should take your time, and if you have something that you wrote down that you'd like this gentleman to read,
I didn't write it down.
then you're going to have to share it.
Okay.
But take your time.
Okay. First of all, I would like to address the fact that it was not March the 4th, 2019 that the defendant walked away from the courthouse. It was February the 23rd. When Judge Reader called for recess, I think it's 45 minutes, we all returned to the the courtroom. The defendant did not return. Judge Reader spoke with the attorney and said, "Where's your client?" And he said he did not know. She said, "You need to get in contact with him." This was going on in the courtroom. He got on the phone and he called Michael Robinson. He said, "Where are you?" He said, "I'm still at the courthouse, but I'm on the phone with my mom." He said, "You need to come back to the courthouse, to the courtroom." So Judge Reader said, "We're gonna give him a few minutes." He never showed up. When we had the preliminary hearing in July of 2017, he was told not to contact me. I had received phone calls where someone would just hold the phone. At first, to be honest, I didn't think anything about it at first. But then when I looked at the phone, I saw this name. I said, "What kind of name is this?" I said, "I know it's not who I think it is, because it's like I thought it said Saeed or something like that." So when I called, somebody answered but did not say anything. So by this time, his mom took the phone. She said, he had a nickname, Kelly. She said, "This is Kelly's mom. He won't talk to you." I said, "He cannot speak to me." Your Honor, it's going to be 4 years. My baby was 23 years old. Courtney accomplished a lot. 3 weeks before she was murdered, she graduated from college. He was jealous of that.
She had secured a position at Greater Memorial Hospital as a medical assistant. He was insecure about that. He wanted to know what doctors trying to speak, trying to talk to her. If she didn't call him at a particular time on her lunch break, he would give her a hard time. The last week, that final week, I saw Courtney alive on Tuesday. That was the last time I seen my child personally. She asked me, could she come home? Now, Courtney moved across the street from me where she was killed. I had to pass that every day. I had to pass that apartment. It's torture. It's a nightmare.
So you still live in the same place,
Yes.
so you see it?
Yes. Now, his attorney mentioned about the screwdriver in the gun. I want them to know that when I spoke with the medical examiner.
No, you can't speak to it.
Okay, all right.
Ms. Way, where did your daughter go to college?
Atlanta Area Tech.
Okay. Well, it sounds like she was doing real well. I will tell you the problem that we have here is that this has taken so long.
Yes.
It is not fair to you. It is not fair to Mr. Robinson. These cases need to be resolved sooner. They take a little while because they're serious and we need both sides to gather their evidence.
Okay.
But the pandemic is the enemy of everyone. I mean, that added a year. This case was ready for trial, I suspect, before the pandemic. I inherited this caseload right as the pandemic started.
Mm-hmm.
We had to close a lot of our operations. Once we were able to think about jury trials, I reached out to the prosecutor as well as to Mr. Robinson's former attorney, not Mr. Franklin, someone else, and said, let's do this. This case is too old. And unfortunately, the answer was, and no one has any control over this, the attorney was changing jobs. And so Mr. Franklin has very graciously jumped back in. He's familiar with the case because as you got to hear from him, he's worked with Mr. Robinson before in this case. And that's good news. That means that we can get this to trial, if it's going to be a trial, sooner. We have started doing jury trials again, and people are getting more comfortable with doing that. We're only doing one at a time, so it's a slow pace, but this is a case that is very, very high up on my list to get on a list of cases that we can try so that we get closure. The jury is going to say whatever they say. It was an accident, it was intentional, it was an assault, so it's murder. I don't get in the middle of that, but I'm going to do my best to at least get us to that point so that Mr. Robinson gets his day in court, which he's entitled to, and then it may be you testify, but at least you'll see that something is being done about your loss. And I appreciate you being here today. I know it's complicated to get into court on any day, but during the pandemic, it's tricky. And I appreciate you sharing what you did.
One more thing.
Yes, ma'am.
All I heard was, well, when he gets out, he'll drop whatever. I just want, if you don't mind, just keep in mind that the day he found out he was indicted was the reason why he was so assured that he was going to be indicted on lesser charges. So I assume that when he found out was the reason why he did not return back to court, because there were serious charges. I plead with you to allow him to stay there until we go to trial. I know it won't bring my child back to me, but I want the right thing done. And I want to see that somewhere, somebody can see that my baby's life mattered. She's not coming back. I know this. But
Well, I appreciate you sharing that. And I know you know this, but I'm going to say it anyway. Your daughter's life, Ms. Roscoe's life, mattered regardless of what a jury says. A jury may hear the evidence and say it was a defective gun and it was a tragic accident. I don't know what they'll do. That doesn't mean that Ms. Roscoe's life didn't matter. It was a tragedy, whether this was intentional, an accident, a stupid game, or he was mad, but didn't mean for it to be that bad. A jury will work through that. But none of those situations is okay because your daughter's gone. And that's the loss that we can't ever make whole again. But my commitment to you, to the prosecutor, to Mr. Robinson and his lawyer is let's try to get this in front of a jury as soon as we safely can do that. And that's what we'll focus on. But I appreciate you being here today.
Thank you for listening.
You're very welcome. Ms. Beza, anything else?
That's it for the state, Your Honor. Thank you.
You're welcome. Mr. Franklin, anything you want to say in conclusion about Mr. Robinson's bond motion?
You're on mute, Mr. Franklin.
I'm sorry. Very briefly, my computer cut out during a portion of Ms. Besa's argument, but what I believe I gathered, there was some concern on her behalf that Mr. Robinson would potentially be a threat to intimidate witnesses. And the one thing that we heard from Ms. Roscoe's mother, to the extent that that was Michael also on the phone, I know she said she spoke with Michael's mom, is that he called to talk. And this silence would almost suggest a somber kind of thing as opposed to a antagonistic type of communication. And I think that it is also consistent that there's no testimony that Miss Way, I believe there was a friend named Nakia, I think I got the name correct, and Rashawn. None of these people can provide testimony as to what happened in the home at the time that the incident occurred. So there's not anything that Mr. Robinson would substantially gain if he had it in his mind to want to harm someone, which again, there's no indication that he wants to harm anyone. He'd been out nearly 2 years before being indicted. And even at the point in time that after he left court, he didn't run to New York or California or Arkansas. He was arrested here in the metro area working. This is where his life is. And we believe that is the best indication of the fact that he'll attend court at the appropriate time, especially with the ankle monitor condition that we requested. And curfew.
Got it. Thank you. So I don't think there's anything about this case that's not complicated. The facts are going to be complicated for any jury to work through. And it sounds like the only witness who survived to what happened is in fact Mr. Robinson. So everything else is going to be what people are able to divine from having investigated the scene or talking to people who knew the couple. The one thing that I seize upon that to me is most concrete is what happened in February of 2019. I don't know what it would be like to be told you've been indicted for murder. It's a little less of a surprise having been in jail on voluntary manslaughter for a while and knowing that there was an indictment. But I have too often recently agreed to put someone on an ankle monitor for a serious situation, and then I get that notice from the ankle monitoring company that the ankle monitor has been removed, and then we don't find that person anymore. And so while I appreciate that Mr. Robinson did not go to Arkansas or any of the other states you mentioned, this case is not getting less serious, and we do need to get it to trial. And I need to know that I can get Mr. Robinson to trial. And the best way to ensure that is to have him where he has been. It is regrettable for everyone that we've added a year to this process, certainly not Mr. Robinson's fault. It sounds like if he had stayed in court that fateful day in February of 2019, he may well have been waiting for his trial on the outside, but he made the choice he did, and none of us can afford having that same action occur again. When we set this down for trial, I need to know that everyone who needs to be here is here, and an ankle monitor doesn't give me that comfort level. So I do not find that Mr. Robinson is a risk of committing additional crimes. Sounds like he led a safe and relatively quiet life until this happened. And there may well have been difficulties between him and Ms. Roscoe. That's not affecting my bond decision. Maybe something that the jury needs to hear about. But I am going to deny the motion for bond and encourage the two sides to continue to get ready for trial. I know, Mr. Franklin, you've had to reclimb a learning curve, but the good news for Mr. Robinson is you're not a stranger to his case. And I don't think there's been any new evidence. And if it was, it would be this information from the crime lab. But the record ought to be fairly complete in Mr. Robinson's case, so that as soon as the defense is comfortable with the trial setting that we have developed in Fulton County, we can get this case back on a trial calendar to give Mr. Robinson his day in court and Ms. Way and her family their opportunity to seek the closure they're understandably seeking. Thank you. Mr. Franklin, while I've got you here though, Ms. Beza, am I right that there are not discovery issues?
That is correct, Your Honor. I actually reserved Mr. Frank. I reached out to him to see if Ms. Vargas had turned over her discovery, and she had not. So Mr. Franklin actually picked up the discovery from our office on the 3rd floor, copied everything for him, and then, so he should have a copy of everything. So even if she turns it over, he'll have a duplicate copy.
Okay, he can get 2 sets. But you believe, Ms. Beza, that what was left on the 3rd floor for Mr. Franklin is your case file?
That is the case file.
Okay, so Mr. Franklin has what you have, including whatever may have come from the crime lab about it, the chamber having been damaged by a screwdriver or something.
Yeah, okay. I sent that to him in an email, just so it's in writing, because there's no report.
Got it. Understood. Okay. So Mr. Franklin, I'll send out solicitations again soon. I've got an update for all the lawyers practicing in my division about the fact that we're going to be opening up these trial calendars to CWAC cases, or whatever we're calling them now, soon. And so when you are ready to have Mr. Robinson's case added to one of these consolidated trial calendars, just let me know and we'll do that.
Yes, sir. My practice has been to ask the clients who fit the criteria for trial, the single defendant, single charge, whatever, to ask them their opinions on the stuff. And so those who tell me that they're interested, I'm gonna submit to the court.
I trust you're handling it in the right way. So we'll go forward when you and your clients are ready to do that.
Yes, sir.
That's all I have for today, Your Honor. May I be excused?
Yes, ma'am. And is this your last day?
Yes.
Good luck with everything.
Thank you.
Then I heard that Ms. Patel is going to be gone for a while too.
Yes.
So Ms. Macaulay will be Ms. Patel, and who is going to be you?
Michelle Sims.
Ms. Sims, whom I've never met, I guess.
She's one of the DV88s. She's taking over this courtroom.
Okay.
Yep.
Great. I hope you left her with all the information she needs.
Oh, I did. Yeah.
Excellent. Well, good luck with everything. All right. Position 5 is a plea and arraignment. I don't think we'll need to take anything down, but we'll see. Ms. Rivers, are you Mr. Velasquez?
Yes, sir.
Can you hear me?
Yes, sir.
Great. And you don't need an interpreter for anything?
No, sir.
Great. So, Mr. Franklin, is this your case? We have an attorney Collins listed. I don't know that person.
Yeah, that's me. Latrivia Collins is one of our non-complex attorneys.
Great. Okay. So, Mr. Velasquez, this should be a pretty straightforward situation. This is your plea and arraignment date. You've been charged with a bunch of counts of terroristic threats, some misdemeanors, and we want to make sure your case is moving along. Mr. Franklin, is Mr. Velasquez going to be waiving arraignment?
Yes, sir. Yes.
Great. Okay. Ms. Hall, anything complicated about this case? And I should let you know when I asked that, Ms. Nelson is doing scheduling orders that have more time for discovery and motions and less time. And if it's not a rape or murder, the default's going to be less time. So things are moving. But I always want to make sure either side could say, hey, this may look just like a burglary, but here's why it's more complicated than that.
No, it's not complicated.
Okay.
It's just surveillance that we need to obtain.
Okay. Well, we will get a scheduling order out, and Mr. Velasquez, your lawyer, Mr. Franklin, will get the discovery in this case. He'll get in touch with you about that. And then if Mr. Franklin decides that there are motions to file that need to be heard in court, we'll get you here for that. So you'll come to court for the motions hearing. If there are no motions that need to be filed, then we will get you onto something like a trial calendar, a way to resolve the case as soon as we can, consistent with whatever time you and Mr. Franklin need. Does that make sense?
Yes, sir.
Great. All right. Mr. Franklin, anything else for Mr. Velasquez?
No, sir. I've already filed my entry. I'll file the waiver of appearance after court.
Waiver of arraignment. Fantastic. Thank you.
Yes.
I think he's done.
Mr. Cruz, I think you're on the call.
Good morning to the Honorable Court. Well, good afternoon to the Honorable Court. Yes, sir, I am on the call.
Great.
How are
and
you?
You represent Mr. Carr?
Yes, sir, I do.
Great. Good afternoon, Mr. Carr. Can you hear me?
Yes, sir.
Great. I'm Judge McBurney. Your case has been assigned to me. Your lawyer, Mr. Cruz, is on the call. And Ms. Hall, the prosecutor, is here in court with me. She's on your screen as well. Today is your arraignment day. So I'm going to ask Mr. Cruz a few questions, and it should be pretty short and sweet. I'll let you know what's going to happen after that. Mr. Cruz, is Mr. Carr waiving arraignment?
No, sir. We have not received the indictment nor the initial list of witnesses. I sent the message about an hour ago to the prosecutor requesting same before Mr. Carr's hearing. So,
okay. Well, she's been here because she got to court a little early, so that may be why she hasn't responded. I'm just looking at the docket right now while we're talking. So you've been in the case for a while, but I guess the indictment is new, and you wouldn't have received a copy of the indictment electronically because you are part of the whole e-filing system, Mr. Cruz?
So the indictment is very new. I believe the indictment is within the maybe I want to say past month, if not sooner, or maybe a little bit later. When we were at the preliminary hearing, well, once I got the notice of arraignment, I was aware of the indictment. I just didn't know who the prosecutor was. I've been speaking with Ms. Grofsky, who's the, I believe it may be the prosecutor on our cases higher up. I could be mistaken, but I've been speaking with Ms. Grofsky. We didn't get into the discussion of the list of witnesses and the copy of the indictment. We were discussing other matters pertaining to the case.
All right. Well, we'll do a formal arraignment then. Ms. Rivers, are you ready?
Well,
yes, Judge, I'm on the record.
Excuse me, Honorable Judge McBurney. Now we can't be arraigned under, I believe it's OCGA 17-16-3. I could be wrong. I could pull up the statute. Until he receives the indictment and the list of witnesses. So if the state can provide it today, we're fine with moving forward from arraignment. But if not, we would ask that, we do receive those documents before we are arraigned.
So here's how it can work. We can wait for 2 or 3 weeks and bring Mr. Carr back virtually and do this again. Or you can authorize me to sign the not guilty plea on your behalf and your client's behalf, and we can move forward today. I'm fine either way. So if you want to take a 3-week break, we'll get Mr. Carr back here. I'll make sure Ms. Hall or Ms. Nelson, who works with me, gets you the indictment, which of course is a public document sitting in the docket that you could get to if you logged in to the e-filing system. You are attorney of record in the system. And so you never did answer my question about whether you got it automatically when it was e-filed, but it is a public record. So I'm happy doing it either way. You tell me what you'd like to do.
Yes, sir. May I speak to Mr. Carr? Can we have a breakout room for maybe 30 seconds?
I think that'll work since Mr. Carr is the last defendant, but let's hear from our detention officer who's been real helpful today. Can I just put you in the breakout room now since there are no other defendants, or would you prefer that Mr. Cruz calls that phone number?
You can do the breakout session, Judge. Thank you.
Great, we'll do that. All right, so Mr. Carr, well, first, Mr. Cruz, Ms. Nelson just emailed you the indictment. So if you want to check your email, it's there, and you can take a quick look at it while you talk with Mr. Carr. Mr. Carr, I'm going to move you electronically into a private breakout room with your lawyer, Mr. Cruz. While you're in there, I cannot hear what you all are saying. The prosecutor cannot hear what you are saying. It will be a confidential exchange between you and your lawyer, other than whoever might be in the room with you, Mr. Carr. You understand?
Yes, sir.
Great. I'll move you two into the breakout room. Mr. Cruz, when you pop back out, we'll know that we should bring Mr. Carr back out, and we'll figure out what we're going to do, okay?
Yes, sir. And I could just ask the prosecutor if your honor is fine with it. The indictment is there. And this will be my first time using the Fulton County system, the e-file system. Would the list of witnesses be there as well?
It is. If you look at the indictment, after count 7, which is on page 4, you get the pages don't have numbers on them. Page 5 has a little bit of detail about Mr. Carr, his booking number, things like that. And then you'll see 2 civilian witnesses and 5 law enforcement witnesses.
Okay. And your honor can see that?
Can you see it or can I see it?
Are you looking at it now as we're speaking?
Yeah, here. In fact, we can all look at it. Do you see it?
I do see it. Okay, I do see it. So it'll be a short conversation with Mr.
Okay, I will stop sharing the document and I will move the 2 of you into a breakout room.
Okay, thank you.
You bet. All right, you should see your invite.
Yes, sir.
What's new, Ms. Hall?
Getting cases ready for trial.
Good for you. Do you have any that are old enough that we might get to try them in this new system? Because most of the old ones, you could second chair it, I hope. Most of the old ones will be CWAC, or although you saw our very first trial was a burglary. We just don't, because you and the lawyers have been working hard on the other side. We don't have someone who's been in jail for a year on burglary, which is good.
Well, one,
Maybe we do.
Rodney asked you, but it may
Resolve. Okay.
But other than that one, I have a lot of 18 cases, but they're complex. The ones that y'all not looking for, but I have a few.
Well, when you say we're not looking for it, if it's multiple defendants, that's a problem. Oh, Mr. Cruz is back. That was quick, Mr. Cruz. You good?
Yes, sir. We
all right, let me hold on one sec. Let me make sure Mr. Carr is back. Are you back, Mr. Carr?
Yes, sir.
Great. Okay. Just want to make sure. Mr. Cruz, did you have enough time to speak with Mr. Carr?
I did, Your Honor.
Okay. So tell me the plan. Would you like to have Mr. Carr formally arraigned? Do you want to waive arraignment and enter a plea of not guilty, or what is your pleasure?
We will be waiving arraignment, but also if I orally may, just request of the court Of course, and I believe I already filed the motion, so I won't even go into it. So we'll waive arraignment, Your Honor.
Okay, and just in case you're worried, gosh, by having been arraigned, we're forfeiting the opportunity to file certain motions. What's going to happen next, and this is for your information as well, Mr. Carr, is that Ms. Nelson, my litigation manager, will enter a scheduling order that sets out some deadlines. The first deadline is actually for the state to get to you, Mr. Cruz, the discovery that the state has right now. There may be some things they don't have yet because something's still at the crime lab or who knows what. But everything that Ms. Hall, that's the prosecutor you'll be working with, Ms. Hall, everything that she's got, she will put into a tidy little package and get it to you, Mr. Cruz. The second deadline in the scheduling order is a deadline for you, it's really for both sides, but in particular for the defense, to file any motions for which we might need to have an evidentiary hearing. So you will have time to process the discovery, look over the indictment. This includes demurs, things like that. So legal motions, not just factual motions, but there will be a deadline for you to file those motions. If you file a motion by that deadline that requires a hearing, that'll be the next time we all see each other, is that we'll get everyone together for a motions hearing, motion to suppress, whatever it might be. If you don't have any motions, or after I rule on the motions, then we get this case onto a trial calendar. So we try to keep this pretty efficient, getting us to the end game as soon as is safe for everyone. Certainly, if something comes up before a trial date that would resolve the case, the state wants to dismiss it, or they offer something that Mr. Carr is interested in taking, we'll get you in the court. You and Ms. Hall would just need to let Ms. Nelson know we've worked something out, and then we'll get you on the next available calendar. But short of that, if you know already this is going to be a trial, you'll get discovery, you'll decide whether you got motions, and then we'll get everyone back here for a trial as soon as we can safely do that. Does that make sense?
That does make sense. And thank you.
You have one more project. Ms. Nelson is going to email you something else. It's a waiver of arraignment form, and I need you to fill that out because that will get us in the docket officially that you waived arraignment on behalf of Mr. Carr, and then we'll get that scheduling order in and you guys will be off and running. Okay. Any questions about any of that, Mr. Cruz?
No, sir, and I'll get the waiver of arraignment back to you instantly.
Okay, fantastic. Mr. Carr, we talked a lot about procedural stuff. We're not talking about the substance of your case today. Do you have any questions for me, or are you going to wait to connect with Mr. Cruz?
I'll wait to connect with the lawyer, sir.
Okay. Ms. Hall, anything else in Mr. Carr's case?
Nothing further from the state, Your Honor.
All right. With that, we're done. Thank you, everyone.
All right. Thank you.
Thank you.
Thank you.
Goodbye, everyone.
Bye.
See you next week.
Have a good holiday.
You too.